So we know representations are statements that you make with an intention of inducing the other party into a contract. If they turn out to be false, they become misrepresentation. So in order for a party to actually claim to sue for misrepresentation, in order for misrepresentation to be actionable, the following have to be in place. In short, misrepresentations can be active if, number one, it must be an untrue statement of fact. It must be made by one party to another before the conclusion of the contract. It must be made with an intention that it should be acted upon by the party to whom it is addressed, and then it must actually have been relied upon and must have been one of the causes that induced the other party to whom it was addressed to enter the contract. Okay, so let's go through all that. Okay, let's go through all those things and see how they actually take place in a contract. Let's start with the first one. The representation has to be one of facts. That is the reason why general opinions and general statements, okay, made by, say, sellers or suppliers, whatever it is, the parties in a contract, those ones will not count as misrepresentation, okay? So they have to be factual statements. This is important because at times sellers just make mere puffing or commendatory statements, and you need to know the difference, okay? You need to know the difference when a seller is just saying something because they are sort of trying to hype whatever it is they're selling, and when they're actually saying something that is factual, okay, something that is going to affect the validity of that contract. Okay, for example, what do you make of the following statements? A statement that a second-hand car is of good value. B, a statement that a car has done 6,000 miles. And C, a statement that a car is the best model ever produced. Which of those statements is a fact? And which one is just mere puffing, okay, mere statements made by a seller because they're trying to sell? Let me know that in the discussion area provided, okay? So you can comment that. Now let's move on to the second one. The misrepresentation must have been made before the contract was concluded. So in order for misrepresentation to actually qualify, it must be an active one, which means it must be something that you said before the contract was done, making it the reason why you actually got into that contract. In fact, a representation which is true and made, but to the knowledge of the other party making it, becomes untrue before the contract is entered into, must be corrected. And failure to do so will turn it into a misrepresentation. For example, in negotiating a sale of a medical practice in January, X represented the takings to be at the rate of $2,000 a year. In May, when the contract was signed, the takings had, owing to X's illness, fallen to $5 a week. It was held that the contract could be rescinded owing to X's failure to disclose the fall in takings. Number 3, the misrepresentation must be made with the intention that it should be acted upon by the person to whom it is addressed. So for example, Z, on the faith of statements appearing on the prospectus of a company, bought some shares in a company from a holder of them. Some of the statements were false, and Z thereupon sued the directors. So it was held that the statements were intended only to mislead the public into being original subscribers of the shares from the company. And as Z was not an original subscriber, but had purchased the shares later from a subscriber, he was not within the class intended to be misled and therefore could not maintain their action. Okay, here's what we're saying. You see, when you're buying shares in or rather when a company is doing their IPO, basically floating their shares, right? They do put out some prospectus. So prospectus simply means any material that is designed to convince the public to buy our shares. Now, there is a liability to prospectus. Like whatever you write into prospectus can hold you liable. In this case, we're talking about the people who signed it. So it could be directors, company secretary, and all that. So in this case, what happened was the things that were written there, some of them were false. But an original shareholder bought the shares and then sold them to somebody else. And so the case was, look, the prospectus were designed to mislead the people who bought the shares first, not the people who bought the shares from the people who bought the shares. That was the argument. So the whole point here is that in order for something to be a misrepresentation, it must be something that made you get into the contract. But remember, the contract in this case was supposed to be between the company and the original purchasers of the shares. I mean, of course, there are ways in which that will not hold place in court. But the point is, you get the context, okay? You get the example. Now, next, the misrepresentation must actually have been relied upon and must have been one of the causes that induced the contract. Which means that if you misrepresent something to someone and then they don't take your word for it, okay? You tell them this and then they're like, yeah, whatever. So they get into that contract anyway without relying on what you told them, then that misrepresentation cannot be used as a ground for bringing an action on that contract or for suing to rescind that contract. C offers a business to D for sale, representing that the takings to be $5,000 a week, knowing that this statement is untrue. And D, after investigating the books, decides as a result of that investigation to buy the business. D will not be able to sue C upon his fraudulent representation as to the takings. But if D relies even partly on C's representation, C will be liable for fraud. Here's the interesting take to that. You see, in sale of goods contract, a seller doesn't really have to disclose some defects in relation to the goods. So if you're buying something, if you're buying any product, okay, and there is something wrong with it, the seller is not, if you ask, they have to tell you that there is something wrong with it. But they are not necessarily supposed to be telling you things that are likely to make you back away from that contract. This is the reason why you have that maxim, caveat emptor, which means buyer beware. Okay, so it's your duty to actually check what you're buying to make sure that it's okay. Although having said that, in sale of goods contract, we still have implied terms and implied conditions. So it's not just the case that you're going to sell something that is not fit for purpose intended and then say, well, caveat emptor will apply. No, okay? There are rules for that. So the point is just that if somebody misrepresents something and then you don't rely on that misrepresentation, then that will kind of render that misrepresentation to be pointless. Something else that you need to remember is that you cannot make a misrepresentation and then say that guy should have done better research to find out if I was lying. That is not supposed to be your defense. Okay, for example, in the negotiation for the sale of X's business to Y, X represented that his takings were $300 a year and produced papers to Y, which he said bore out his statement. Y bought the business without examining the papers. If he had examined them, he would have discovered that X's statements were false. It was held that Y had relied on X's statements, and so he would rescind the contract, and it was no defense to say that he had the means of discovering their untruth. So, those are some of the requirements, okay, that have to be met in order for misrepresentation to actually hold ground in a court or in a legal proceeding. If there is any question, as always, do let me know. See you in the next video.